tackle an issue that, often is not talked much about, but even if it's talked about, it's often, comes with very, very different opinions. We're talking about child custody. It's something that it leaves emotional imprints that last a lifetime on both parents, children, and just people involved. And the question you're asking this morning is what happens, when marriage ends and the question of who takes the custody of the child begins. And to help with this, we have Silas Akira, that is an advocate of the High Court and a family law expert. Silas, karibu sana to TV47. Thank you for making time.
Thank you very much. Nashukuru.
All right. I want us to just, first of all, start by understanding, when you talk about child custody, when do people or parents get to this particular point where now child custody is a topic of discussion, an issue of concern between these people who have chosen to be parents? When you talk about child custody, how do they get to that particular point?
Well, thank you so much for having me on studio here once again. First of all, the understanding of child custody for the benefit of the viewers is that child custody is the legal right and responsibility a parent has over the welfare, growth, and development of a child. And now, when we talk about when the question of custody arises, it is not typically when the marriage ends. Could be there existed no marriage at all. Maybe it was a come-we-stay or sort of cohabitation. Some of them call it hit and run. But at the end of it, there is this desiring of a child. So according to the Constitution, the responsibility over this child is to both parents, whether married or not, whether together or not. So at the stage where the growth, development, care, protection, and welfare of this minor is put to the table, then we begin to ask who has custody. So custody is actually split into two. We have the legal custody, which are decision-making powers over the child. And then we have the actual physical custody, who has the actual physical presence of the minor, of the child. And so legal custody is in our country or in common law practicing nations is considered to be joint, because the law grants each parent equal right to make decisions over a child. However, actual physical custody can be granted to one parent, because if they are separate, then they cannot have actual physical custody of this child at the same time. So what happens is that it is considered that children below the age of 10 years are in need of the mother's love, care, and attention more than they need the father's active presence. So you find that most courts will grant the actual physical custody to the mother for a child below the age of 10 years. Unless, remember, this rule is not absolute, unless it can be proven to the contrary, that one, the mother exhibits insanity and is incapable of taking care of the child, and two, if there is some longer period of abandonment, if given birth to a child, for instance, you abandon the child with the father. As we say in Swahili, chukua mzigo wako.
Yes.
And the mother runs away, and then the mother wants to come back at age 7. Remember, that is still below 10 years. The mother wants to come back at age 7, seeking what? Custody. So this is a question that courts have to pronounce themselves. If this father was able and capable of taking care of this minor from age 0 to age 7, what will be difficult for him to take care of this minor from age 7 to age 10 and beyond? So these are some of the issues or things that are considered when granting actual physical custody. Remember, I said that legal custody is joint because the father can give decisions with regard to the child's education, religion, beliefs, traditions. The father can also give decisions with regards to the child's general welfare, growth and development with or without having the actual custody. Yes, please.
But when you talk about joint custody, is it truly viable in the Kenyan context, you know? And if there are barriers, then what barriers hinders its enforcement?
Well, it is difficult to have joint actual or physical custody, but joint legal custody, it is very possible and enforceable because as we look ahead, we have about 6 categories or 6 spheres under which responsibility, parental responsibility kicks in. Now, if each and every parent is granted legal custody to the minor, meaning, remember I said legal custody here is the decision-making right over the minor. If the child wants to go to school A, there has to be consensus between the 2 parents. The mother calls the father, or the father calls the mother, that I see gift should be taken to school A, because school B, he is not performing properly. Remember, they are conversing over the decision on the child, meaning they are exercising their joint legal custody. However, at that time they're exercising this joint legal custody, the mother or the father may be having the actual physical custody. You see? Yes. So that is how the joint legal custody is exercised. Alternatively, there can be an alternating actual custody. We've handled one particular case for foreigners, particularly residing in Kenya, where the court granted the mother custody, actual physical custody on all public holidays, school term holidays, and weekends. While the father, being a teacher by then, was able to provide the nitty-gritties of the minor, and so it was considered that the child would be best taken care of on the longer run when with the father. So the court split the physical custody between the father and the mother. And in this circumstance, we would say that there is shared custody. We call it shared custody. But then there are circumstances where the mother or the father is given absolute or total custody, the full custody of the minor, and then the father is given reasonable access, and sometimes also denied access because maybe the circumstances of the father's health conditions is violent and all those things that we can mention that can make the child to fear being close to the father. But even then, because it is considered that naturally the child needs the care and protection of both. There is the love from the mother, and then there's the discipline and nurturing from the father. So in these circumstances, some courts do give what we call phone or virtual access at given periods within the day. You are told that provide a phone and a SIM card for the minors. Maybe after school, when they are from school, you can help them with their homework and now engage one-on-one through phone calls, through teleconferencing, video conferencing with your children, and then so be part and parcel of their, even if you are denied the actual physical custody. Yes, please.
So in this case, when you're saying that a parent could be denied total custody, will they still be required to pay child support for this particular child? Or if you're denied total custody, you're also excluded from just paying child support?
Not really. You see, when you talk about parental responsibility, this one is a constitutional right. And when the courts are making decisions concerning parental responsibility, they look at what we call the best interest of the child. Now, the best interest of the child is paramount in every decision being made by the courts. Sorry, in the Constitution of Kenya, particularly Article 53, 1 and 2, towers above any other responsibility or above any other principle the best interest of this child. Is the decision I'm making as a magistrate, as a judge, to the best interest of this child? So if to the best interest of the child, one parent must be denied total custody, and the other be granted full custody. For instance, this usually happens majorly for traveling parents. One has to go to the US, for example, or to the UK or China or wherever abroad, and the other has to remain. So in this circumstance, you see, the prevailing circumstances do not grant physical access. So the court has to make this painful determination of splitting the two parents from their children. So one parent has to remain or has to go with the children. So then, in these circumstances, or even if they fail to agree, they're within the same jurisdiction, but they keep fighting, they threaten the lives of the children, they threaten the development of the children, and the court has to make this painful decision of granting one full custody and the other no custody. Responsibility for these parents still remain intact. You cannot wish away responsibility simply because the court has denied you. Remember, there are also rules of natural justice, which they exercise by themselves, the parents. The parent does not want to go to court, and the parent does not want the father to get involved. And the mother decides, I can feed my child. So by that, the mother relinquishes sort of the father's rights to contributory responsibility. Or sometimes the father can say, I've tried to access my child to no avail. I feel there is no need of fighting with, they call this woman, even in courts. So let her proceed with her children. I will not participate. So on rules of natural justice, that is how they do. But when you go to the court setting, it doesn't matter who has custody. Parental responsibility is a shared responsibility, and it's a 50-50 affair. Yes.
When you're talking about the best interest of the child, to what extent does it apply? And in the sense of, you know, a child says, I want to go with mom, I don't want to go with dad, or I want to go with dad, I don't want to go with mom. How is their best interest now being put to play at that particular point?
Now, particularly, best interest comes to fight for growth, development, and welfare. Welfare, growth, and development of the child. So where these three are going to be properly taken care of, then any decision of the court towards that direction is considered to be in the best interest of the child. For instance, we have a scenario where a mother went to court. I'll give this example. A mother went to court. Already she had physical custody of the child, and her financial stability was way too low. Very, very low. And her argument was the father of the child has to take care of the child in terms of shelter, that is rent, in terms of clothing, in terms of food, in terms of education, medical, absolutely everything. That her contribution here is just being with the child. So the court considered that the father has better chances of taking care of the welfare, growth, and development of the minor. So the mother is financially incapacitated. Remember, the court is doing this to try to dissuade Kenyans from the notion of, let me trick him, I'll get financial support from him. Really not for the child, but from him, for the mother's own consumption. So you find that in such scenarios, you find that the advocate has drawn a case for the mother, and the mother is seeking everything under the sun. Then you realize that the target here is not in the best interest of the child, but in the best interest of the mother, which the court does not consider. So the court granted the father custody, full custody, and granted the mother access, and told the mother to look for, I think it was around 50,000, if I can remember the case very well, 50,000 per month to be contributed to who? To the father, for the welfare and the maintenance of the child. Because it is a 50-50 affair. It can flip when you think you have it. For instance, the clip that your producer sent to me over this discussion, you find the content creator there indicates that sometimes you might go to court thinking you have it, and thinking you've cornered, thinking you've hit the jackpot. Now you're going to siphon as much as you can from this gentleman. And then the court flips it over against you and tells you, hey, you are financially too low to take care of welfare, growth, and development of the minor. So in other scenarios, as you've said, when the children are of a certain age, probably 5 years and above, courts do engage them. While their testimonies are not taken seriously, they are considered. So the probation officer or even the court just plays around with the child and takununulia bigiji, unaendeleaje, unaenda shule.
Manipulation.
Yes. No, not really manipulation, just to get to know, to get the child to talk.
All right.
Unakaa na daddy. Daddy anakununulia nini? And then the child now, unataka kuishi na nani?
Okay.
And then they're like, mimi nataka kwenda na daddy. I want to go with my father. So the court considers that. When making judgment, the court will consider that the child himself or herself has preferred or recommended to stay with the father. So in such circumstances, it will be considered to some extent. After other considerations or factors have also been put together, it will be recommended that this child goes with the father. And those are the kind of drama and issues we see in courts, where a court decides to grant custody to the mother or to the father or whoever the child has not chosen. And then as soon as the court is done, the hammer is hit and the opposing parent takes the child, and then you see wailing and crying around the courtrooms. They don't want the mother, they don't want the father, they just want the parent they feel comfortable with. Yes.
And you know, when you talk about sometimes, you know, custody goes to the mother, especially when the child is below 10 years old. Has it ever worked against, you know, the unemployed mom let's say she is emotionally available, she's taking care of the kids well, but you know, somehow she's unemployed, and then the court does not favor her in terms of just getting custody of these children?
Yeah, sometimes it does work against the low-income mothers, let me call them like that, where the court considers that the factors are necessary for the brooding of welfare, development, and growth of the minor are well catered for by the father, then the court would always flip to the father and against the mother. However, it is of importance to note that that is when financial disability is coupled with other factors. However, minors of below 10 years are recommended to be with their, we call them children of tender years, because they still need the nurturing of their mothers. You see, for example, when you go to our well-abled content creators, comparing when the child is left with the mother at home, and then when the child is left with the father at home, you find that the mother is pampering the child, the mother is quite afraid the child's going to hurt, but then the father puts the child on under certain conditions you deem risky, and maybe he's been lifted with one leg up, and then they say now, that is the upbringing of the father. The father tries to teach you what you're going to face in the world. Then the mother tries to give you that comfort. When you face this trouble, run back to my breast. I will give you the comfort. You understand? So all these things are needed for the growth, welfare, and development of the child. And so that's why courts do consider these days, by the way, the trend by very well-learned judges and magistrates is to foster custodial cases, child custody by consent, to try and bring the parents together. Can you imagine when the father sends school fees to school, gets the child on SHA or whatever medical health coverage that he has, and maybe a little financial contribution, but then the two are not together.
Yes.
There is just how it affects
the child.
Yeah, whether they are doing their responsibility to the required degree by the law, but if the parents are not together, there is just that disconnect. A very, very big gap. So courts have seen it wise these days. And by the way, majority of the children matters that we have handled, we have tried the much we can as advocates, as counsels. We note the counsel on the other side, and then we begin discussions of how to have a consent, bring these two parents together, really not to get you back to the marriage you've run away from, really not to get you from the relationship you've run away from. Probably it was a coincidence that it was an unfortunate situation that this happened, but we try to bring you together, at least in one way or another. Your children see you taking them out together.
Yeah.
You see, at that circumstance or under that scenario, Mr. Dida, you'll find that children are growing properly.
Yes.
As opposed to, let me take my responsibility, let me do my part, she does her part.
Wakili, just hold on to that point, because I know you would want you to explain it further and tell us if it does work in Kenya, for instance. But in the meantime, interact with us on our socials, TV47 Kenya on Facebook and YouTube, on X at TV47 News KE. My handle is at Ann_Dida. Send in your feedback. We're talking about child custody. Have you gone through this process before? Talk to us. We'll be back in a short while.
Siasa, mamlaka, sera na utawala, nani hufaidika, nani hupoteza? Katika ulimwengu wa siasa, ukweli haufichiki, lakini nani mwenye ukakamavu wa kusema? Tunauliza maswali magumu na pia majibu tunakuletea.
Hata Rigiji alituaibisha sana, acha nikuambie.
Unajua kweli ni kwamba Spika Wetangula alipigiwa kura na wabunge.
Huu ndio ukumbi, uga wa mijadala ya kitaifa, ulingo wa uchambuzi wa sera, kinamasi cha ukweli. Lakini siasa bila wewe haziwezekani. Ungana nasi katika ukumbi wa siasa kila siku ya Jumanne saa 1 kuendelea, na mimi rubani wako Elizabeth Motiko.
Separating eggs. Use an empty plastic bottle to separate the egg yolk from the white. Hold the bottle upside down and gently squeeze. The yolk will suck right up into the bottle, leaving the egg whites where you need them.
Hey kids and families, get ready for the most fun-packed show around, Kids on the Block. Join us for awesome music, magical storytime adventures, and super cool arts and crafts. Plus, we pop tasty treats in our cooking corner. Learn, laugh, and create with us. Kids on the Block, where every day is a brand new adventure. Don't miss it.
What are sports all about? Winning,
Our world is changing every day, and so should we, for the better. Each week, we tackle the big why, the question that should be on everyone's minds. Why isn't this fixed yet? Deforestation, global warming, and the adverse effects of climate change. The future isn't just something that we inherit, it's something that we create. Join us on The Green Fix as we tell the stories of those who refuse to give up.
All right, welcome back. Thank you so much for staying with us. You're watching Morning Cafe, and this morning the conversation you're having is understanding child custody laws with Silas Akiro, an advocate of the High Court. And of course, we're inviting you to be part of this conversation on our socials, TV47 Kenya on Facebook and YouTube, and on X at TV47 News KE. My handle is at Ann_Dida. Send in your comments. And Silas, you know, when we're just starting this conversation, I made a comment that this decision mostly leaves a life, an imprint, you know, for life on the mother and on the child and maybe on the father as well. But who do you think exactly gets affected the most? Is it the child or the parents, you know, before we continue from where you stopped?
Basically, the child gets affected the most. Just like the Swahili saying goes, fahali wawili wakipigana ni nyasi huumia. So the nyasi here becomes the child.
Yes.
And so you find that, and that is why the Kenyan judiciary or the justice system specialized a court for children, where You may have slapped one another, beaten one another, chased one another up to the police station, sorry to use those words. But when we face this particular court, we are absolutely talking about the issue of the child. Whereas some of parents' issues might take center stage in the decision-making process. For instance, if the parents fought and they've been fighting, so the one who is aggressive, the aggressor is considered violent and not a safe haven for the child. But Kenyan judiciary set up a specialized court for children. And the magistrates who handle children's matters are also highly trained on children issues. Not just any magistrate sits as in the children's court.
Before we went on that very short break as well, you were talking about how you as advocates, you try to bring the parents together, having them take the children, together as parents for an outing or whatever they want to do, but as parents, But does it actually work? Or sometimes, when you're talking about parents having so much ego, to just come together and sit down at the same table, does it work in the Kenyan context?
Let me tell you, to some extent it does work, but to some extent it fails. So I would say Kenya, we are heading that direction. We are not yet there. Because for parents who typically have the best interest of the children at heart, they have no problem negotiating. Their main issue here is the child. Take your part, let me take my part. So they can negotiate on how they're handling some of these issues. But for parents, particularly, it is more on the mothers who use this opportunity as a bait for financial gain.
Yes.
It is difficult to bring them together. Because when they are brought together, we pass them through the categories of responsibility: food, shelter, healthcare, clothing, education. And then you want to tell a mother who wants to be paid for food, shelter, anataka lipiwe rent. He wants to gain rent from this father, wants to gain shelter, food from this father, wants to gain clothing, and wants to gain huge financial monthly support from this father. And you want to tell her that now you have to relinquish 3, take 3. It's not going to work.
Yeah.
In fact, there will be a lot of appeals. Appeals from magistrates court to the high court and sometimes went to the court of appeal. Issue being, he wants the father to take care of everything, which the law right now has declined. And it becomes worse when you have a combative lawyer. You got a lawyer who takes your issues with emotions. Takes your issues with emotions. Drafts like somebody quarreling. You can see the way somebody puts their issues in court documents. So the lawyer is more aggressive, more aggrieved than the mother. In that circumstance, believe me, mediation won't work. Even when the mother would wish to attend that mediation, the advocate will say no. So to some extent, we lawyers interfere much without knowing that my actions today are going to affect the interests of this child in the future, when the parents themselves had no issue sitting down on a round table and sorting out their issues. So for me, the practice I have, or rather that I have met, the magistrates before whom I have appeared, some of them, you'd hear the way they address advocates. They would tell you, like there's a matter I got mid-course. And they're like, wow, counsel, thank you so much for coming on record in this case. I know with you on board, we are now going to have some of these issues sorted. But remember, as I speak this word, there are certain parents who are not happy because they don't want any negotiation at all. What they want is, what I have placed there, let me get it. And it becomes even worse, Mr. Leader, when the parent wants $500,000 financial contribution. Then you are here representing another parent. You inform the other advocate and the other parent that this is not going to be possible as per the law today. And then you knock out the $500,000 to barely 7,000 contribution per month. Because yes, you have the father has taken care of school fee, which is close to 150,000 Kenya shillings. That is 150,000 shillings per term. The father has taken care of health care, which is equally a chunk of premium today in the Kenyan context. Leave alone SHA. There are those who go an extra mile to get private medical cover. It's a chunk of premium. And then you still want to get this father again to put another $500,000 on the table. Those are the ones now we talk to the opposing counsel. And then we ask the opposing counsel, would not wish the parent to be disappointed when the ruling or the judgment comes, because we already know we can predict. I normally tell my clients that unlike when the law was developing, you would go to court with your briefcase, with your wig, you are dressed properly, and then you argue a case and win. These days, cases are won based on the provisions of the law. Everything has been provided for. You would speak 1,000 words and the magistrate will ask you, thank you so much, counsel, for your submission. What does the law say? It stops there. So we'll discuss that the law has already outlined the stakes of parental responsibility, the contribution by each parent. The law has already outlined it. Why do we go an extra argument when these are things we can simply just even sit down between advocates, do what we call parental responsibility agreement, file a case in court, an application, and adopt this agreement, and we close this case. So you, the father, every month, every term, this is your responsibility. You, the mother, every day, every month, this is your responsibility. I mean, child matters, child custody issues are the simplest. I tell you, the law on children has simplified everything. But since we want to battle, you find cases going up to the Court of Appeal. So you wonder, what is this case going to do at the Court of Appeal when the law has already simplified things for us? Yes.
We already have questions in here for you, and Chris Fodotando is asking, what if you live outside the country na mmeachana but bado you want to be involved lakini mama yake amekataa? Is it still considered as abandonment?
Really, it will be considered that you have deserted your responsibilities. What you need to do is to file a case against the mother in court for access. So that there are, like I had indicated, we have the actual physical custody, and then we have the access. Now, access is also categorized into around 4. We have the unfettered access. You have all-time access to the child. Whenever you want, you can drive in, see, hi baby, how are you? Did you get my candy? And have your chat with your child. Then we have supervised access or reasonable access. This is where the court orders you to, orders the mother to avail the child to the nearest police station. The father will come, interact with the child within that confine, and then go. And then we have phone access, where the father or the parent who wants access provides the phone and a SIM card dedicated for the children. And then at a particular time given by the courts. So normally they say all weekend, anytime, weekdays, maybe after school hours, 7:30 plus, but before 9 p.m. because then they need sleep also. You can make a call, have a discussion with your children, get to know how they're faring on. And then we have the virtual access, where you set up a video conferencing. Talk of Microsoft Teams, talk of Google Meet, or whatever. And you have your children in real-time conversation on video conferencing. So these are available for parents who are very, very far. For example, those who are abroad. If the court cannot grant them access to go, custody to go with the child, then they can ask for phone access or video access from court.
Okay. Kevin Mashisia is also asking, I'd love to know if she insists on living with the children, but the living arrangements are too crowded and I live alone. Can I seek custody?
Exactly. If you can prove that, one, the living arrangement is too crowded, two, she's unable to provide an alternative living arrangement, or number two, the living arrangement affects welfare, growth, and development of the child. Three, she's unable to provide an alternative. And four, the prevailing circumstances are such that the child is going to be greatly affected and their growth, welfare, and development is going to be heavily hampered with, then you can seek custody of the child.
You know, when you're talking about background check, when you're doing this background check, what do you look into, you know, to ensure that you get the facts right? If you're looking at Kevin's comment here, he's talking about if he's living in a very conducive place, but the mom's place is too crowded. But as for you, if you're doing this background check, how do you now ensure that your facts are right, to also just ensure that your case is heavy enough?
Well, like I said, I've not seen this compacted and fast approach by courts outside Nairobi. But within Nairobi, when the magistrate or the judge grants the first direction to the advocates or to the parties, they say, file your affidavits of means. So each and every party is going to put in the affidavits of means. So in this affidavit, they'll state living conditions, their earning, stretches of their earnings, the requirements of the child, and the affidavit of means is going to detail a lot. Plus, sometimes parents do have their way, especially when the dispute now reaches a point where we have to go to court. Maybe one parent has tried to seek access to no avail. And by the way, when you find, we normally say that men are, I'm not really pro men that much, but men are those people who die inward. They don't like to let out their emotions. So when you find a man going for access, filing a case against the lady, majority of the cases we have is a mother filing against the man. But when you find a man filing a case, then it means he has tried his level best. Mama atapiga simu siku mbili tatu, sema, oh, you don't want to take care of your child. All right, let's meet in court. But the father will try and try and try and try. Before the father files for access, maybe he has even maneuvered around, knows where you live, has experienced those threats. If you dare come close, utaona and all that. And then now they proceed to court. By that, they have factual evidence of how, maybe when they call the child, they see the background, how things are. The house is one bedroom. You have like a crusade of people living in this, not even one bedroom, bed sitter. You have a crusade of people living in the same place. The hygiene is not proper. The child is sleeping on the floor. So you see, these are things that hamper growth welfare, growth, and development of the minor.
You know, you said you're not pro-men, and I would love to know why. Because, you know, when we're talking about the courts and the judiciary lends more towards giving women custody. And are we looking at it from a point where now courts are evolving, you know, towards a more gender-neutral stance when we're talking about child custody?
Certainly, exactly as you put it. Courts are evolving towards gender neutrality. And in fact, one of the trite law or decision currently running in our judicial precedences is that children are not means of unjust enrichment. So, what does that mean? When you are deciding to get a child, also decide from the day that conception is going to take place, also decide that you're going to have a 50% contribution. So if you know you cannot get that 50% contribution, do not allow the siring of the child. Because that is how courts are, on a neutral ground. But remember, some of my seniors have tweeted on what we call jurispresa, where money changes the corridors. Sacks walk the corridors of justice. That is where you find a parent who is not working is given 48,000 per month per child, and they have 4 children. That will come to around 192,000 per month. Where is he going to get it?
Yes.
And he doesn't even have work. So you find that normal or judicial decisions, you'll find the court granting school fee. Basic. You see, the law is on basic education. In fact, there is the Basic Education Act. And then we have the Children's Act. So where parents cannot manage high-end schools, the children are taken to public. That is fairness. And then the father is tasked with looking for school fee, books, transport, food, and what have you. And then the mother has custody, and the father does minimal contribution, 3,000, 6,000. I remember there is one who was granted 6,000 per child, and she was like, oops, this court, let's appeal. They appealed, the court granted 2.5, 2,500 per child. Children are not means of unjust enrichment.
And Jen Blessed is also asking, what about us when your baby dad ndiye ako na mtoto and I try everything possible to support the kid, but anasema yeye ako sawa, atajilelea mtoto, hana shida. And what hurts me the most, alikataa niwe naona mtoto.
Proceed to court. Get access. If the child is of tender year, you can get both access and custody as a mother. But if the child is above the tender years, then you can be granted access. Remember, it's a 50-50 affair. When one parent has physical custody, the other must get access. And the other can only be denied physical access on certain grounds. I said, tendencies of violence. The child is not safe with your presence. There are those parents that if you just appear, the child just begins to cry. And cry running away literally. But you are the father. Why? The child is not comfortable near you. Or you are the mother. The child is comfortable with the father. I see this meme where, I think it's an American TV series, where the gentleman is so emotional how he's taken care of his child, his son. And the son is now very old, almost twice my age. But they've gone for DNA tests at that age. I know the child is mine. The mother said the child is not yours. The child belongs to the caretaker. Then the father would be like, the court now asks, how did you know this child is yours? Did you take a DNA? No, ma'am. What I did, the child was crying. I held the child by my hands, and I said, keep quiet. And the child went silent. So he says, according to him, there is some connection. And he told him, no, this is my child. So there are certain connections that fathers have with their daughters, with their sons. That even if you try to seek custody, the child himself or herself will cause you to not get that custody. Because even if, for good magistrates, the moment they hit the hammer and the mother crosses over to take the child, and the child begins to make the heaviest noise in court, you know what they do? They review the orders immediately. Custody to the father. Immediately. She's sealed her decision, she's delivered the ruling and the judgment, everything is done. The mother crosses over to take the child, nduru zinaanza. The magistrate calls the court back to order, reviews the decision.
They're there.
They're there.
And you know, when you talk about abuse, emotional abuse, how do now courts verify allegations of domestic abuse or psychological abuse? And in instances where you see maybe both parties are accusing each other of, you know, abuse?
Like I said, children's matters are handled especially in children's courts on properly legislated grounds. However, where parents claim domestic violence, physical assault, and abuse, they always present to court the evidence they have in their mainstream courts. Remember, assault is a crime in Kenya. So you file a case against the man or the woman at the criminal court. So what evidence will be required with? Will be required with a medical report. Because when you're hurt, you need to get checkup. The first thing, I remember the first time I came, one of the presenters here asked me, when you're assaulted, what do you do first? Go to the hospital first or go to the police station first? Then I said hospital. Maisha kwanza. Go to the hospital, get the treatment note, run to the police station and report. Because then if you don't go to the hospital and you rush to the police station, the first thing the police will ask you, where is the evidence? But if you go to the hospital first, then you'll get the treatment notes, medical report, and the police would ask you where's the evidence, you present, and then they take the OB. So there are medical reports to be presented. There are witnesses, neighbors. Some go to the extra mile because they want unfettered custody and they want to close the child from the father completely. They coach the child. We've seen those cases where the child goes to court, demonstrates how daddy alinyonga mami and what have you, and one in the children's court, the father is denied custody, and then the criminal court, the father is taken behind bars. Several years down the line, the child is guilty. Remember, you may think the child is so young to be able to recognize what you're doing. But later on, you find this very same child who was 3 at the time or 4 or 5 at the time, still recounting how you coached that child.
Yes. Just hold on to that thought. Because, you know, we've seen a case, somebody was released 17 years later last year after a similar issue that you're talking about.
Sure.
Stay with us. You're taking a very short break at this point. We're talking about child custody laws. Interact with us on our socials, TV47 Kenya on Facebook and YouTube, and on X at TV47 News KE. We'll be back.
Our world is changing every day, and so should we, for the better. Each week, we tackle the big why, the question that should be on everyone's minds. Why isn't this fixed yet? Deforestation, global warming, and the adverse effects of climate change. The future isn't just something that we inherit, it's something that we create. Join us on The Green Fix as we tell the stories of those who refuse to give up. When it comes to fixing the planet, there is no time to waste. Join me, Shiksha Arora, on Thursdays at 9 p.m. on The Green Fix as we look into the big why, you and I.
For comprehensive information and education on your health, Body Garage is here.
Don't allow anyone to pluck out your good tooth as long as it is strong and stable.
Cancer doesn't start today and you get the symptoms tomorrow. By the time you pick it or the time it is manifesting in you, probably will be there about 5 to 10 years.
The eye is the window to the rest of the body.
Don't forget to stay hydrated.
And of course, you at home do take your water.
So the ultimate test is actually you check your urine. Your urine should be clear.
Clear like the water?
Yes. Should be able to see the other side.
I got reason. I got good reason to believe so. Yeah, man, ever living, ever faithful, ever sure. Jajaranting, Lord of Lords, a King of Kings.
Just think about it.
Our world is changing every day, and so should we, for the better. Each week, we tackle the big why, the question that should be on everyone's minds. Why is it...
Welcome back. You're watching Morning Cafe. The conversation you're having this morning is understanding child custody laws with Silas Akira, an advocate of the High Court of Kenya. We are already seeing your feedback, so keep sending them in at TV47 Kenya on Facebook and YouTube, and on X at TV47 News KE. But Silas, I just want you to finish up on that point that you're talking about. You know, when you notice sometimes children come to court and they are coached, you know, to say 1, 2, 3 by the other parent, and then it comes back at them when they are older. But you know, when you're talking about children being coached, you as lawyers, as advocates, do you actually notice that this child has been coached, or do you just go straight in with whatever they've said?
Really, that is now the technicality of the rules of evidence. Mm-hmm. If at the time you know truthfully that this child has been coached, mm-hmm. the onus shifts on you mm-hmm. to prove otherwise, that what the child is saying is not probably true. Mm. The child has been coached. Mm-hmm. The court will not go with a shout, Your Honor, this child has been coached. Mm. Substantiate your allegations. Why do you say the child has been coached?
Yeah.
Now, that is where the difficulty comes, and the court carries the child's testimony. Mm. And like I was saying, as a parent, you can do this to your child. Maybe the child is 3, 4, 5. Basically, the ones coached are between 5 to 7 years, mm-hmm. or 8. And years later, this child is haunted. Mm. The child is in school, sees other fathers bringing candies and whatever to their children, but you've never seen your father.
Yes.
Reason? You foolishly took your father behind bars. And this thing continues to eat you. Now let me address the parents. This thing continues to eat your child up to their teenage years, where now they can make certain decisions. Remember, when guilt overpowers the human nature, they hate the person who caused this guilt. They begin to hate the mother. They don't like the mother completely. To the extent when you go for visiting, anaambiwa mamako amekuja. Achana na huyo fala.
Now the resentment shifts towards
Yes,
the mother.
exactly. Exactly. So that is why we say, I normally tell the opposing clients, or even if the mother is my client, do this in a manner that gives the father the opportunity to love both the mother and the child. Don't make the child, the father to hate the mother and love the child alone.
All right.
It's not going to go well. Yes, please.
Lucy Mora is saying, missing this after I have received a letter, mtu akikosa kuapia, what will happen?
Really, if it is a letter, then they are in the demand stage. So you can respond to the demand. It's advisable, but you can also fail to respond to the demand and wait for court documents, the documents from court.
Okay.
Now, if you fail to appear, remember the proceedings in court. They file, they take out a memorandum of appearance, they serve it on you, it gives you 15 days. If you fail to appear, everything they have requested in that case will be granted by court.
All right.
Even if they have requested for 150,000 contribution or 250,000 contribution, because you failed to appear and they have proven that they served you, then you are relinquishing your right to defense. So the court will grant everything in that case.
Oh, wow. Larry Black, na baby mama mwenye anakatalia mtoto hataki umuone na anarusha maneno, unamfanyaje?
Court, children's court.
The answer is the court.
Court.
Julie Jane, she's saying, I hate co-parenting because I know it's disturbing. I decided to go silent and never ask for anything from him. Since peace is what I was looking for, I hate drama. I don't want those court trips. That is Julie, that's a comment. What happens to a shared custody once the lady has been married by another man?
It doesn't end, or whether the parents are together or not. Remember I said Article 53 of the Constitution, particularly Sub-Article 2, parental responsibility continues to the child's 18th birthday, or if extended to the 25th birthday. But whether you split, marry each other, what remains a fact is that you being married to that man is still the mother of this child. Him being married to another lady is still the father of this child. So you have to take care of your child, come rain, come sunshine. And the court can compel you to do that.
All right. This one, his username is Twitter. And he's saying, my ex-wife took me to court to get children's support and full custody while I was with the children and her without any responsibilities. We got 50-50 custody and now she has to pay school fees. That's a comment.
Yeah. That's what I was telling you. It shifts. Sometimes mothers think they're going to get the whole heavens out of it, and then it shifts the other side.
All right. Brother Nasema, my baby mama made this mistake. Alikimbia children office and ended up giving me more power over my child. Sahi anajilaumu. That's a comment as well. And the final one is, mimi mtu akikatalia mtoto ama she uses the kid to blackmail and extort me. Siwezi shindana na yeye, natafuta mwingine mwenye heshima na tuzae na maisha yaendelee mbele.
Remember that, let me comment about that.
Okay.
That is your life with your baby mama, but there is the life of the
child.
But
now, Wakili, what happens to this, children who are under a polygamous setup? How is the child custody now divided?
It is, you only have one mother, one father at any given time on this earth. Whether your father has married many wives, the fact is, among those many wives of your father, your mother is only one. So when you talk about child custody here, it is between your father and your biological mother. And where now one parent, sorry to say, demises,
yes.
Then the responsibility now remains on one father. Sometimes the state can come in to support. That is why we have now these support for orphans and the vulnerable children. Yeah, so the state can come in to cushion the father. And some parents do not know that those support exist.
Yeah.
So they go it all alone, but they go as they complain and lament. Yeah? Yet they can just make a few applications and they get support.
You know, I wanted to ask that question. You know, what happens now when one parent dies or disappears? Can it automatically shift to the surviving parent now?
Exactly. It is automatic. It is automatic shift because it's a parental responsibility and biological parents.
So in this case, you don't look at now the emotional stability of the parent, the financial status, automatic?
Automatic. But in certain cases, the family of the demised parent proceed for guardianship, adoption, and the courts grant, even with one parent leaving, if the best interest of the child is going to be well taken care of by the family of the demised parent, the deceased parent. So still, but if there is no otherwise, that the family of the deceased parent have declined to take care of this child, or they're kicking the child out, and the child has to go to the streets or to be taken to corrective institutions, then the other parent will have to be given responsibility with stern warning, and probation officers are ordered by court to do the monitoring.
Okay. And of course, Wakili, in your final remarks as we wind up this conversation, you know, post-custody enforcement mechanism, is the law saying anything about it in cases where, you know, a parent has been given custody, but he or she is not doing what they need to do, you know, just fleeing jurisdiction? So is there an enforcement mechanism after custody has been given to a particular parent?
There are judgments that are rigid, Mr. Dida, but children's matters, judgments and rulings are never rigid. They can be reviewed as necessity arises. We have situations where the father gets custody, wants to fly out, has paid tickets. The mother says, bring me my child to greet me before the child leaves. Then the mother is there putting the child on recording. Mimi nataka kubaki na mami Kenya. Now, the mother refuses to release the child even against the order. We have to go back to court. Or if the recording is genuine, the mother returns to court to review the same judgment that was given yesterday, that the child's interests have now shifted. So everything is to the best interest of the child, but some courts do only permit reviews after every 2 years.
All right. Once again, the answer is always in the courts, and you talked about this is a very, very easy thing to do. Wazazi sometimes wanakuwa vichwa ngumu. And of course, as we said when we're just starting off this conversation, this is something that leaves an emotional imprint that lasts a lifetime. And Wakili here says mostly on the children. We're talking about understanding child custody laws with Silas Akiro, an advocate of the High Court of Kenya. Thank you so much for watching. Thank you so much for staying with us. But right about now, we are going to the farm. We're talking about kuku farming, chicken farming, right away.